discretion contrary than the way you would otherwise like. The lender comes back and provides your client with a short sale agreement, and it says, we're going to come after you for the deficiency balance. And your client looks at that and says, well, rain on that. I'm not going to do the deal. And the buyer, who's been waiting patiently for the past 6, 8, maybe 12 months, it says, wait a minute, time out, foul. Hey, we got a contingency built in to this sale agreement, but it only says upon lender approval. Your lender approved it. He agreed to release the lien. You're saying, well, yeah, but he's going to come after me for the balance. Yeah, but that's not what the agreement says. It just says upon lender approval. Be careful. Be careful there. Now the car forms, the California Association of Realtors, bless their hearts, they're trying. They're trying. But the problem when you use any type of template form is you cannot cover every combination or permutation of events that are going to occur in society. And therefore, they are going to let you down from time to time. It's just that's the way it is. We're not robots. Human beings tend to be a little random. So, the car forms do have the most recent ones in the short sale addendum has language in there that it's not worded quite as well as I would like to see it, but it's better than nothing. But instead, I would make it clear that there are conditions precedent that must be satisfied before the seller becomes obligated to perform. That is, the seller's obligation to perform does not spring into existence until certain conditions are satisfied. And those conditions are each of the lenders encumbering their property must contractually agree to relieve the sellers of their obligation to pay the remaining balance on the loans. The contract has to be adequately worded to the satisfaction of an attorney of the client's or the homeowner's own choosing. Oh, I like that. Why do I like that? Is it self-serving? Does it give me a lot of business? Well, kind of. But the reason I like it is because it puts the homeowner in the position of control. It puts the position of control. It gives them the power of choice to say yes or no to the transaction. And that's what's important here. Because you don't want the buyer to come back and say, because if the buyer sues the seller, they're essentially saying, your obligation to perform has already arisen. Therefore, I'm suing you for specific performance. You have to perform. Your obligation to perform has arisen. And what I'm trying to do is create the document so that the seller's obligation to perform has not yet arisen. We're trying to push off that obligation to perform as long as possible. We're trying to put as many conditions into it as possible to give them the flexibility to walk away. If their lender comes back and plays hardball with them. Have you seen lenders playing hardball with some of the sellers? Yeah. Do you blame the lenders for playing hardball? No, they're their own money. Their own money. Yeah, here, I put it right there. Sellers will have no obligation to perform under this agreement unless an attorney of seller's own choosing finds the wording of the lender's short sale agreement acceptable. Each of seller's lenders with a loan secured by the property must contract, okay, yeah. Address the 1099, the tax bill with them. Address the tax bill with them. Now, what I want to emphasize about the taxes. Okay, there we go. There's a citation for the Seacrest case. 4th District Court of Appeals, 2008. Yeah, no signature, likely not enforceable, statute of frauds. Okay, anybody in here doing loan modifications? No loan modifications. Then we don't need to talk about the laws regulating loan modifications. Should you discuss credit? Ooh, that's a good one. Somebody, I don't remember who, asked me a question about credit or something. At the beginning, I don't remember. Credit. I consider credit to be the C word. I call it the C word. Especially in light of the most recent financial intervention by the current administration. What has happened, ladies and gentlemen, with credit cards as of lately? Yeah, they're getting canceled. The interest rates on them are skyrocketing. People who have $15,000 on credit card debt are seeing their payments go from $500 a month to $1,500 a month. I tell people this: don't talk about credit. Why? Who cares how Bank of America is going to report on this one specific account? If the client does not have control of their finances, then the destruction of their credit is a foregone conclusion. A judgment lien appearing on their credit is devastating. A tax lien appearing on their credit is devastating. And once one creditor starts garnishing wages and starts emptying out bank accounts, it has a domino effect on all their other financial obligations. I think it is incredibly irresponsible to zero in on that one real estate loan and say this is going to solve all your credit problems. I've asked many realtors this question. You're dangling the credit stick. What's their FICO score today? What's their FICO score going to be after you're done? Well, exactly. Let's stop talking about credit. Why are we talking about credit? Credit is a symptom. It's not the problem. It's the symptom of lack of control over one's finances. If you treat the symptom, it's going to reoccur. Treat the problem. What's the problem? Not paying their bills. Address the bills. You address their financial distress, you deal with it, you eliminate it, the credit will eventually take care of itself. Kind of makes sense, right? Nobody can credibly argue different. And if you're sitting there building the client's expectations up that they're not going to suffer any detriment to their credit, or their credit's not going to suffer be as bad, but yet one of the junior lien holders sues them, or a credit card company sues them, well, they're going to be a little upset. You said, my credit wouldn't be negatively impacted, or this badly impacted. It's the surprise component. Now, there is an act out there. It's called the Credit Repair Organization Act. It's a consumer protection statute. Here's what I want you to understand about consumer protection statutes. It is human nature within the real estate profession, the legal profession, all professions, any profession that is providing services to consumers, to say, well, those consumer protection laws, they don't apply to me. If I interpret this statutory reading of this code just so, get all the planets to align just right, and if I look at it in the leap year, then it doesn't apply to me. That's called a narrow construction of the law. It's disfavored in the courts. Narrow Organization Act applied to you folks. That's the $1 million question. Now I'm going to tell you, I'm going to be honest with you. Maybe, maybe not. It depends upon what you're doing. It depends upon what you're doing. If you are dangling the credit or the credit carrot in front of the client to induce him to do a short sale. What is at the heart of the transaction? Is it credit repair? Or is it the short sale? There's the million-dollar question. It depends upon what you're selling. It depends upon what you're selling. And I am telling you right now, credit very seldom comes into play here. Now, if you have a client that is completely current and does not carry a balance on his credit cards or a very small balance, and he's got the income to pay it off every month, and the only thing giving him a hard time is this one real estate loan, well, that's kind of sort of a client where then maybe